Dissenting opinions. Thurgood Marshall's influence on the Supreme Court endures in no small part because of the passion, depth, and foresight of his many dissenting opinions. While a justice's majority opinions carry the force of law, dissents often serve as powerful counter-narratives that shape legal discourse for years, sometimes decades to come. In Marshall's case, these dissents revealed not only his stance on specific doctrinal points, but also his broader understanding of constitutional commitments to justice, dignity, and equality. Whether challenging the death penalty, critiquing the erosion of criminal procedure safeguards, or lamenting the court's reluctance to address systemic discrimination, Marshall used the dissenting platform to memorialize arguments that might otherwise have been subsumed by the court's majority. Many of these positions have gained increased resonance and acceptance over time, underscoring the forward-looking nature of his jurisprudence. In this section, we examine 5 of Marshall's most notable dissents, each illustrating different facets of his judicial philosophy. Gregg v. Georgia, 1976, his foundational death penalty dissent after capital punishment was reinstated. McCleskey v. Kemp, 1987, a passionate exposition on racial inequities in capital sentencing. United States v. Leon, 1984, a critique of the good faith exception to the Fourth Amendment's exclusionary rule. Wygant v. Jackson Board of Education, 1986, a defense of affirmative action and a call to recognize the historical context of racial inequalities. San Antonio Independent School District v. Rodriguez, 1973, an early dissent that laid bare Marshall's commitment to robust equal protection in matters of education and socioeconomic disadvantage. By delving into these opinions, we gain insight into how Marshall employed dissent, not simply to record disagreement, but to offer an alternate constitutional vision rooted in empathy, historical awareness, and a conviction that the law must serve society's most vulnerable. Gregg v. Georgia, 1976, Marshall's moral and constitutional rejection of the death penalty, historical and procedural context. Following Furman v. Georgia, 1972, the Supreme Court had effectively halted the death penalty by ruling that existing capital statutes gave juries excessive discretion. States responded by devising new laws designed to channel juror discretion and reduce arbitrariness, including guided sentencing procedures, aggravating and mitigating factors, and automatic appellate review. One such revised statute in Georgia came under scrutiny in Gregg v. Georgia, 1976. The question before the court was whether these legislative fixes rendered the death penalty constitutional once again. In a series of opinions, the Supreme Court upheld Georgia's capital scheme, concluding that states could impose the death penalty under carefully crafted statutes designed to prevent random or discriminatory imposition. The decision effectively ended the 4-year moratorium that Furman had ushered in, allowing executions to resume. Thurgood Marshall joined in this stance only by Justice William J. Brennan, Jr., dissented from this return to capital punishment. Marshall's core arguments. Marshall's dissent in Gregg encapsulated the comprehensive case he would make in nearly every subsequent death penalty case. That capital punishment is inherently incompatible with the Eighth Amendment's prohibition on cruel and unusual punishment. His dissent proceeded in 2 major parts. Evolving standards of decency, building on Trop v. Dulles, 1958, which had introduced the concept that the Eighth Amendment must be interpreted in light of evolving standards of decency. Marshall argued that the death penalty could not be reconciled with a modern moral consensus. He systematically rebutted claims that capital punishment served as a uniquely effective deterrent or was the only means of retribution for the most serious crimes. Informed public opinion. Marshall advanced what came to be known as the Marshall hypothesis, positing that if the American public were fully informed about the death penalty's realities, its arbitrariness, high costs, racial disparities, and questionable deterrent effect, most would find it morally unacceptable. He stressed that continuing support for capital punishment reflected in large part ignorance of these systemic flaws. The dissent's legacy. Marshall's dissent in Gregg laid down a marker for all his subsequent capital punishment dissents. Although the majority was unreceptive to his abolitionist stance, Marshall's arguments shaped the intellectual terrain for future critiques of the death penalty. Scholars often cite his empirical approach, the Marshall hypothesis, as a key insight into how public misinformation undergirds continuing support for executions. Moreover, his unremitting reference to evolving standards of decency has found resonance in narrower contexts, such as the court's eventual prohibition of executing juveniles, Roper v. Simmons, 2005, and the intellectually disabled, Atkins v. Virginia, 2002. Even if Marshall's broader objective blanket abolition was not realized, his Gregg dissent remains a foundational text for those who argue that the death penalty is irredeemably flawed. McCleskey v. Kemp, 1987. Race, Capital Punishment, and Systemic Inequities. The Baldus Study and the Court's Reluctance. 11 years after Gregg, the Court revisited capital punishment in McCleskey v. Kemp, in which Warren McCleskey presented a rigorous statistical analysis, the Baldus Study, showing that Georgia's death penalty was disproportionately imposed on black defendants who killed white victims. Despite the evidence that race played a potent role in sentencing outcomes, the court's 5-4 majority concluded that McCleskey failed to demonstrate purposeful discrimination in his individual case. Thus, the court declined to find a constitutional violation under the 8th or 14th Amendments. Thurgood Marshall's dissent in McCleskey stands as perhaps his most impassioned critique of systemic racial injustice within the criminal justice system. He regarded the majority's stance as a profound abdication of the court's duty to confront the real-world implications of racially skewed capital sentencing. Marshall's dissent, a closer examination, constitutional mandate to address systemic discrimination. Marshall insisted that the Constitution requires courts to engage, not ignore, empirical evidence of systemic bias. He argued that by demanding proof of intentional discrimination in a specific case, the court set a virtually insurmountable bar, thereby sanctioning the continued interplay of racial prejudice in sentencing. The Eighth Amendment's requirement that the death penalty be fair, just, and reliable was, in his view, irreconcilable with ignoring robust statistical data that race influenced who lived and who died. Historical context of racial bias, citing America's legacy of slavery, Jim Crow, and ongoing racial disparities, Marshall argued that the court could not pretend the criminal justice system existed in a vacuum. In states with deep histories of racial violence, systemic discrimination would not evaporate merely because statutes were facially colorblind. For Marshall, the majority's refusal to acknowledge this context reflected a deeply flawed interpretation of the 14th Amendment. Warning on the slippery slope. Marshall underscored that if the court disregarded these statistics in the death penalty context, a similarly dismissive approach could and would be extended to other areas of criminal justice and beyond. The ruling suggested that as long as discriminatory impacts remained generalized and not tied to a single provable instance of purposeful bias, the Constitution offered no remedy. Long-term impact. While the court never formally overturned McCleskey, legal scholars routinely describe it as one of the most regressive decisions on racial justice in the Supreme Court's late 20th century docket. Nonetheless, Marshall's dissent remains an enduring call to recognize and rectify institutional bias. In the years since, civil rights advocates have invoked his arguments in legislative arenas, pointing to the data-laden approach he endorsed as the clearest measure of systemic inequities. Though not binding law, Marshall's dissent stands as a moral and intellectual touchstone for those who continue to challenge racial disparities in sentencing, from the death penalty to non-capital punishment realms. It also resonates with modern discussions of critical race theory, as it exemplifies how purely formal equality can mask the deeper structural workings of prejudice. United States v. Leon, 1984, defending the Fourth Amendment from good faith erosion. The rise of the good faith exception. Postmap v. Ohio, 1961, the exclusionary rule mandating that evidence obtained in violation of the Fourth Amendment be suppressed stood as a cornerstone of criminal procedure. Yet by the early 1980s, a more conservative Supreme Court was seeking ways to limit what it perceived as the exclusionary rule's rigidity. In United States v. Leon, the court adopted the good faith exception. Even if a warrant is later found invalid, evidence gathered under that warrant would not be excluded if officers reasonably relied on its validity. Justice Marshall dissented vigorously, joined by Justice Brennan, arguing that the majority's compromise undermined a core deterrent function of the exclusionary rule. Key points of Marshall's dissent: deterrence as a constitutional imperative. Marshall insisted that the exclusionary rule was not mere judicial policy, but a necessary tool to enforce the Fourth Amendment's protections against unreasonable searches and seizures. He feared that the good faith exception would embolden careless or even reckless warrant applications, knowing that any errors might be forgiven if courts deemed the police objectively reasonable. Judicial integrity. Central to Marshall's critique was the concept of judicial integrity. Suppressing illegally obtained evidence serves not only to deter police misconduct, but also to keep courts free from the taint of unconstitutional behavior. By allowing evidence derived from an invalid warrant, the court risked normalizing incompetent or misleading practices in the warrant process. Slippery slope to further exceptions. True to form, Marshall warned that if the court granted a good faith loophole for warrants, it would likely lead to further erosion of the exclusionary rule through subsequent expansions. History vindicated his concern, as subsequent decisions found additional exceptions, including inevitable discovery and harmless error expansions. For Marshall, each chipping away at Mapp's bright-line principle threatened the real-world efficacy of Fourth Amendment rights. Significance for Fourth Amendment jurisprudence. Leon was a milestone in the court's shift away from the robust police oversight that characterized the Warren Court era. Although the modern Supreme Court continues to uphold the good faith exception, Marshall's dissent is repeatedly cited by those who argue for a stricter approach to police misconduct. It presciently mapped how a single exception could spur further judicial lenience, culminating in less deterrence against unlawful searches. In broader terms, Marshall's stance showcased his enduring suspicion of state power. He believed that the Fourth Amendment, if not vigorously enforced, would fail in its core mission of protecting citizens from unjustified government intrusions. Leon exemplifies how his dissents often combined a textual understanding of constitutional provisions with a firm sense of the practical outcomes that legal doctrines produce on the street, particularly for disadvantaged communities. Wigand versus Jackson Board of Education, 1986. Affirmative action and historical awareness. Post-Baca ambiguities. Following Regents of the University of California versus Baca, 1978, the legality of affirmative action programs remained contentious. In Wigand versus Jackson Board of Education, a local school board policy protected minority teachers from layoffs to preserve diversity in the faculty. White teachers who were laid off challenged the policy, claiming it discriminated against them in violation of the Equal Protection Clause. A divided Supreme Court ruled 5-4 that the layoff policy was unconstitutional. The majority argued that layoffs imposed too direct and individualized a burden on non-minority teachers, and that the school board's interest in a racially diverse faculty did not justify that burden. Justice Marshall dissented, calling attention to the historical context that the majority overlooked. Marshall's dissent, remedial imperative and contextual judging, long-standing racial injustices in education. Marshall began by situating the case in the broader narrative of racial segregation and underrepresentation. He stressed that minority educators historically faced systemic exclusion from public school faculties, especially in high-status or predominantly white districts. Affirmative action for Marshall was not a preference, but a necessary corrective measure for these entrenched imbalances. Narrow tailoring versus unrealistic demands. The court's majority found the layoff policy insufficiently tailored to an identified remedial need. Marshall responded that by requiring hyper-specific evidence of recent direct discrimination, the court set a nearly impossible standard for boards seeking to address ongoing underrepresentation. He deemed the policy a proportionate step toward ensuring that students had minority role models and teachers from diverse backgrounds, objectives that advance broader educational and social goals. Reluctance to recognize systemic racism. Marshall pointed out that the majority's analysis treated layoffs as a purely colorblind question, ignoring the structural disadvantages that had limited minority hiring, promotion, and retention. By focusing on reverse discrimination, the majority neglected the centuries-long legacy of discriminatory practices that had shaped teachers' opportunities. Legacy and affirmative action doctrine. Although Wygant did not directly overturn Baca, it signaled that the Supreme Court was increasingly skeptical of certain race-conscious policies, even if they aimed to remedy historical underrepresentation. Marshall's dissent became a clarion call for considering the deep social and historical context behind racial disparities. When later cases such as City of Richmond versus Croson, 1989, and Adirondack Constructors, Incairn versus Peña, 1995, mandated strict scrutiny for virtually all race-based measures, they made it even harder for local and state governments to address systemic inequality. Nevertheless, Marshall's Wygant dissent echoes in modern debates over diversity-based admissions and other forms of affirmative action. He anticipated that ignoring structural inequities undercuts the 14th Amendment's original aim, securing meaningful equality for those who had been subjugated by law and custom. While the court continued to restrict race-conscious programs, Marshall's viewpoint laid intellectual groundwork for future arguments that diversity and remediation require a contextual, historically informed analysis rather than a simplistic colorblind approach. San Antonio Independent School District versus Rodriguez, 1973. Socioeconomic inequality in education. The school funding controversy. Just a few years after Marshall joined the court, he found himself in dissent over a case that tested the limits of equal protection in education. San Antonio Independent School District versus Rodriguez, 1973, involved a challenge to Texas's reliance on local property taxes to fund public schools, resulting in wide funding disparities among districts. Plaintiffs argued that this scheme unfairly disadvantaged students in poorer districts, thereby violating the Equal Protection Clause. The Supreme Court, in a 5-4 decision, rejected the claim that education was a fundamental right under the Constitution and held that the Texas system did not discriminate against any suspect class. The majority applied a rational basis test rather than the strict scrutiny that typically applies to fundamental rights or suspect classifications, and found the funding scheme constitutionally permissible. Marshall dissented vehemently, arguing that poverty and unequal access to quality education merited more searching judicial review. Marshall's dissent, substantive equal protection for the poor, education as a fundamental interest. Marshall criticized the majority for downplaying education's centrality to exercising other constitutional rights such as speech, voting, and civic participation. He argued that the ability to read, understand complex information, and advocate for one's interests is intimately linked to effective citizenship. To him, a system that relegates children in poor districts to substandard schools perpetuates entrenched social stratification. Revisiting the two-tiered approach. At the time, the court employed a two-tiered approach to equal protection. Strict scrutiny for suspect classifications, e.g., race or fundamental rights, and rational basis review for everything else. Marshall argued for a more nuanced, contextual approach. He believed that classifications tied to poverty or that severely impacted education should trigger heightened scrutiny, bridging the gap between typical strict scrutiny and a mere rational basis test. Historical inequalities and structural barriers. Reflecting the same historical awareness that marked his other opinions, Marshall pointed to the legacy of economic and racial segregation in Texas and elsewhere. Systems that rely heavily on local property taxes, he reasoned, merely reinforce these inequalities. Without a judicial remedy, families in low-income areas would remain locked out of the political clout that wealthier districts enjoyed. The influence and aftermath. Though Rodriguez has not been overturned, Marshall's dissent helped spur legislative and state court reforms. Many states, faced with glaring funding disparities, turned to their own constitutions to enforce more equitable school finance systems. In fact, numerous state Supreme Courts cited arguments akin to Marshall's, often concluding that education is a fundamental right under their respective state charters, even if not federally recognized. Marshall's dissent foreshadowed how the interplay of race, class, and geography can entrench disadvantage an issue that resonates in ongoing debates about the best way to fund public schools. His call for a more flexible equal protection analysis has inspired legal scholars who question the strict binary of strict scrutiny or rational basis, especially in contexts involving fundamental social goods like education or health care. In this sense, even though he could not sway the majority in 1973, Marshall once again seeded ideas that would later find traction in diverse policy and legal forums. Common threads in Marshall's dissents and their broader relevance. Examining these 5 major dissents from Gregg and McCleskey in the capital punishment arena, to Leon in search and seizure, to Wygant in affirmative action, and Rodriguez in educational funding, reveals consistent themes in Thurgood Marshall's approach to constitutional interpretation, contextual and historical awareness. Marshall believed the court must remain attuned to the socio-historical forces, slavery, segregation, entrenched poverty that shape modern disputes. In his view, ignoring these contexts leads to superficial rulings blind to the realities of those most vulnerable to unjust laws and policies. Empowerment of the powerless. Whether defending indigent defendants from police overreach or championing poor children stuck in underfunded schools, Marshall took seriously the Constitution's capacity to protect marginalized groups. His dissents argued that the court should interpret the 14th Amendment in particular as a powerful tool to remedy structural disadvantages, not simply as a mechanism to forbid overt discrimination. Living constitutionalism and evolving standards. Marshall's repeated invocation of evolving standards of decency in the Eighth Amendment context extended, in a broader sense, to his general reading of the Constitution. He saw the document as adaptable to new understandings of equality and justice, whether that meant reevaluating capital punishment, recognizing the pervasive harm of racial bias, or ensuring all children receive a quality education. Insistence on practical efficacy. Marshall's dissents consistently attacked formalistic rules that, in practice, failed to secure genuine rights. In his view, declarations of a right to counsel or to a fair sentencing process were meaningless unless courts took steps to guarantee those rights functioned effectively in everyday scenarios. This principle informed his critique of minimal good faith checks on police and of the court's hands-off stance on racially skewed capital sentencing. Moral clarity, coupled with legal argument. Much of Marshall's rhetorical power stemmed from his ability to weave moral reasoning into robust legal analysis. He did not view constitutional law as morally neutral or purely procedural. Rather, he believed the Constitution enshrined commitments like equal protection that inherently carried moral weight. His dissents underscored that ignoring these moral dimensions led to rulings that might be logically consistent with precedent, yet fundamentally inconsistent with the spirit of justice and human dignity. The enduring significance of Marshall's dissenting voice. While a dissent does not hold immediate precedential force, history is replete with instances where dissenting arguments influence future legal developments. This phenomenon applies strongly to Marshall's opinions. Death penalty reform. Though the court has not abolished the death penalty, it has progressively narrowed its application, banning executions for juveniles, intellectually disabled offenders, and those convicted of non-homicidal offenses. These incremental steps echo Marshall's moral condemnation of a punishment he deemed irreconcilable with human dignity. Racial justice advocacy. Even if McCleskey remains controlling law on the question of statistical evidence for racial bias, Marshall's stance fortifies legislative and advocacy efforts challenging systemic racism in the criminal justice system. His scholarship-like dissent, loaded with historical and sociological insights, continues to guide policymakers who design reforms to address discriminatory policing, prosecution, and sentencing. Criminal procedure protections. Marshall's caution in Leon about diluting the exclusionary rule resonates in ongoing discussions about police accountability. Legal scholars frequently cite his arguments to call for limiting or rolling back the good faith exception. The dissent endures as a blueprint for a stricter approach to deter unconstitutional searches. Affirmative action in education. Marshall's explicit confrontation with structural inequality in Wygant and Rodriguez sets the stage for continuing debates on affirmative action and school finance. These rulings remain vital for those who argue that the court's colorblind or minimalistic approach disserves communities historically subjected to discrimination and chronic underinvestment. In reflecting on Marshall's dissenting legacy, it becomes clear that his role was not merely to critique the majority, but to present an alternative constitutional narrative deeply rooted in the 14th Amendment's original mission to secure substantive freedom for the newly emancipated, as well as for future marginalized groups. His dissents remain relevant precisely because they articulate a vision of the law that resonates with ongoing social justice movements, reaffirms moral imperatives, and recognizes that court rulings must never turn a blind eye to deeply embedded inequalities. Conclusion: Marshall's dissenting opinions as a roadmap for future generations. Thurgood Marshall's dissenting opinions are, in many respects, the fullest expression of his judicial philosophy. Unencumbered by the need to forge compromise or preserve narrow majorities, these dissents reveal the unfiltered convictions of a justice who saw the Constitution as an instrument for protecting individual dignity, curbing abuses of state power, and confronting the nation's shameful legacy of racial and economic injustice. They also highlight his willingness to engage with sociological data, historical context, and moral arguments, an approach sometimes dismissed by textualist or originalist colleagues, yet foundational to Marshall's reading of a living constitution. From Gregg to McCleskey, from Leon to Wygant and Rodriguez, Marshall's dissents propose an alternative path forward, one in which the court accepts responsibility for dismantling structural barriers and ensuring that constitutional ideals translate into tangible protections for those at society's margins. While he occasionally stood as a lone or near-lone voice, his critique of the majority's reluctance to face systemic flaws has only grown more prescient as contemporary debates center on mass incarceration, racial disparities in policing and sentencing, inequality in education, and the ongoing reevaluation of capital punishment. Indeed, even after his retirement in 1991 and subsequent passing in 1993, Marshall's dissenting opinions continue to serve as rallying points for legal scholars, activists, and progressive jurists. Whether or not the court adopts his arguments in full, they remain integral to America's constitutional dialogue. In a legal culture that often prizes brevity and minimalism, Marshall's forceful, meticulously documented dissents stand as enduring monuments to the idea that the court must do more than preserve the status quo. It must strive to fulfill the Constitution's highest promise, justice for all. About the author, Johann Drolshagen is a seasoned technology expert with deep expertise in cloud architecture, software engineering, system administration, DevOps practices, and content management systems. His professional experience spans diverse roles, including technical leadership, strategic consulting, and innovative digital solutions development. In addition to his technical pursuits, Drolshagen is an accomplished author and researcher, specializing in the intersection of technology, law, and governance. His extensive body of work includes books, scholarly articles, and policy analyses, exploring how emerging technologies such as artificial intelligence, cybersecurity, data privacy, and blockchain interact with legislative frameworks and public policy. Through his writings, Drolshagen seeks to bridge the divide between technological innovation and legal governance, creating valuable resources for policymakers, legal professionals, technologists, and academics. His multidisciplinary approach supports the development of informed, adaptable legal systems capable of responding effectively to rapid technological evolution, thereby fostering equitable and sustainable policies in an increasingly digitized global society.